Welcome back to Quick Bits for October 21st. It's going to be a busy week because I'm covering Florida versus Sarah Boone. She's accused of killing her boyfriend by leaving him zipped into a suitcase. And on Friday, October 18th, the trial finally got underway after the jury was seated, starting with opening statements. And then the state got through 10 witnesses. I imagine that trial is going to go quicker than anticipated and that Sarah Boone will be on the stand sometime next week. So if you don't want to miss a moment of that trial, which is actually zooming along pretty smoothly, you're going to want to make sure you have the Lawnerd app at lawnerd.com. It's free for iOS and Android, and it's the best way to stay in touch with what's going on in court because I know trial days are long days, but I will keep you up to date whenever anything goes down, and particularly when the defendant takes the stand. And in today's Quick Bits, we're going to be talking a lot about trial because Charlie Adelson is asking to get a new trial and has some very interesting arguments. Tom Girardi would also like a new trial. Alex Murdaugh, well, he is still asking for a new trial, but he also has a settlement. And the reporting on that got it a little bit wrong. So, we're just going to pull up the settlement document and tell you what the real story is between the settlement in the case of Mallory Beach. And because that's a lot to get into, we should just get into it. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. Charlie Adelson is asking for a new trial, and if you have been following along with either Donna Adelson's case or Charlie Adelson's case, then you might know what this is about. If this case is new to you, Charlie Adelson was tried for the murder of Dan Markel, who was his brother-in-law. Dan Markel was divorced from Wendy Adelson, and there was contentious child custody litigation ongoing at the time of his murder. It's alleged that Charlie Adelson, who has gone to trial and been convicted, Donna Adelson, who is pending trial, and others participated together to carry out the execution-style murder of Dan Markel. Right before Donna Adelson's trial, in a unusual turn of events, her defense attorneys were all removed from the case by the court because of a conflict of interest. Donna Adelson's lead attorney had represented Charlie Adelson in his trial. Well, when that all went down, it was very interesting to see that Charlie Adelson was saying that he did not waive the conflict. He was not going to allow his former attorney to potentially cross-examine him if he was called as a witness for the state. And it came to light that there were no written conflict waivers. Well, at the time, I thought that was just related to written conflict waivers as Charlie was pending appeal and as Donna was going to trial. But it seems that there's a lot more to that based on Charlie Adelson's new motion to the Court of Appeal, asking them to send the case back to the trial court because of this conflict of interest with his trial counsel. Will Charlie Adelson get a new trial? Well, this is a really interesting problem for the court to tackle, and I don't think the judge in this case is going to be happy about it at all. Attorney conflict is one of those issues where if an appellate court is looking to overturn something, this is one of those things that's going to do it. So I don't know if we will see a new trial for Charlie Adelson, but I will not be surprised if we do based on what is coming to light in this new motion that was filed on October 16th. So again, the motion is asking just to relinquish jurisdiction, asking the appellate court to send this back to the trial court for a decision. But what they bring forward in their motion is a lot. So we're going to take a look at that motion real quick because it's a quick bits. I mean, they're kind of quick bits. They're quick for Emily bits, but because I'm covering trial, I don't want to let this go too long because Charlie Adelson might get a new trial here and we need to talk about it. So the points that his new appellate counsel are bringing forward are kind of wild. They start out with saying that the murder of Dan Markel occurred in July 2014, just to reorient the appellate court to this case. They say that in 2016, the probable cause affidavit naming Sigfredo Garcia, Luis Rivera, and Catherine Magbanua, which I am probably mispronouncing, were also listing Charlie Adelson and Donna Adelson. Now, Sigfredo and Luis were the gunmen in this case. Catherine was kind of the go-between between Charlie and allegedly Donna and Sigfredo and Luis. So they were all named in 2016. Here comes something that I did not know. In 2016, attorney Daniel Rashbaum was Donna Adelson's attorney for the purposes of the investigation. Not just the family lawyer, not just a lawyer that she knew, not a friend who was a lawyer, but he was Donna's lawyer for the purposes of the investigation into the murder of Dan Markel. In 2022, they say appellate Adelson, but appellant Adelson in this case is Charlie, so I'm going to keep referring to him as such. In 2022, Charlie Adelson was charged with the murder of Dan Markel. Rashbaum filed a notice of appearance on May 9th, 2022. Charlie Adelson did not validly waive the conflict of interest involving Rashbaum's representation of him at trial and Rashbaum's prior representation of Donna Adelson. Oh boy. They also say Donna was listed as a witness by both the state and the defense. How is Donna gonna be a witness for the defense when he had represented her in the course of the investigation? It goes on to say, a review of the record on appeal establishes that a conflict waiver inquiry was not conducted by the trial court, and then has a footnote about that. If you followed this case, you would have seen the court go through this with Donna Adelson numerous times on the record, over and over and over again. I have to wonder here if the court was unaware of the prior representation. Not that there was just a relationship that Donna knew this attorney, but that he actually was working with her in the investigation. And I wonder what Rashbaum is going to have to say. But Rashbaum was already kicked off of Donna's case because of his representation of Charlie. But is it going to be the case that he should have been off of Charlie's case because of his prior representation of Donna? The motion goes on to say on September 22nd, 2023, Donna Adelson, Rashbaum's former client, was listed as a state witness for Charlie Adelson's trial. It should have come up then. It goes on to say on September 22nd, 2023, Donna Adelson was listed as a witness for the defense for Charlie's trial. In October 23, Rashbaum withdrew Donna from the defense witness list in Charlie Adelson's case after a hearing where the state was seeking to compel Donna Adelson's interview. They're like, you've listed her as a defense witness. We want to know what she's going to say. And the defense was like, yeah, no, we're not going to do that. It says in October and November 2023, Charlie Adelson was tried and convicted, all while represented by Rashbaum. In November 2023, Donna was indicted and arrested for the murder of Dan Markel. And then they go on to say, in a November 2023 recorded conversation leading to Donna Adelson's arrest, which is interesting that those jail calls were what led to her arrest. And if you're curious more about Donna Adelson's jail calls with Charlie Adelson, I broke those down on the Emily Show podcast. I will link that to this episode of Quick Bits. It's over on the Emily D. Baker channel or any of your podcasting apps. It's an interesting listen as Donna was fairly candidly talking on a recorded line shortly after Charlie Adelson's conviction about the fact that she was going to bounce. And they bring it up in this motion. They say in the recorded conversation that led to Donna Adelson's arrest, Donna discussed advice she received from Rashbaum regarding whether she would be able to leave the country undetected prior to being arrested for the murder of Dan Markel. Quote, look, we have to make a decision at some point. After speaking to Dan this morning and knowing what they're thinking up there, they being the state, up there being Tallahassee, she lived at the time in Miami, and what they're thinking up there, I don't know if we'll make it out in time. Make it out of the country is what she means. It goes on with her quote to say, I really don't, because Dan said you might, or you might do all of this, get to the airport, and they'll stop us. And that could happen. It could happen. I don't know, but it's worth a try. So when I also covered the arrest video of Donna at Miami International Airport, she's sitting there going, why are you stopping me? What are you doing? What is this about? Girl, you knew exactly what it was about. You were talking to your lawyer about whether you could run and if you could get out, because there were no restrictions on her movement until her arrest. And then she was talking on a recorded call about the fact that she was going to flee the country. And they hooked her up at Miami International Airport, and she has remained in custody since. It goes on to say in December 2023, Charlie Adelson, represented by Rashbaum, was sentenced. In January 24, Rashbaum appeared as Donna's defense attorney for trial. And all the lawyers were like, uh, so in law school, we learned about this thing called conflict, and it seems like this falls squarely within everything that we talk about. How is this even a waivable conflict? Because the most common defense for co-defendants, especially co-defendants that are co-conspirators that are tried separately, is to blame the other dude. And yes, in this case, I'm referring to Donna Adelson as dude. I'm from Southern California. Everyone gets referred to as dude. Ask my mom. In high school, I referred to her as dude, and she hated it. Everyone's dude. But the some other dude did it is one of your go-tos with co-conspirators. Hey, the other person that's not here, and in this case, it would have been Donna, the other person that's not here, that's the person that's responsible for this. That's the person that's really behind it. That person's the mastermind. You know, that person or Taylor Swift, somebody's the mastermind. But could Rashbaum have brought that defense when he also owes a client duty of loyalty to Donna because he represented her in this investigation before she was charged? That is the type of conflict the rules seek to avoid. An attorney owes their loyalty to vigorously and zealously represent their client. And how can you do that when both clients' defenses may point to the other one? When Charlie's best defense at trial might be, have you met my mother? This was her. I was just carrying out what she was asking me to do. So he couldn't make those arguments. He couldn't bring some other dude did it, or the other co-conspirator did it, or even the empty chair, the person not sitting in court, that's the person who's responsible. He couldn't make those arguments because his lawyer couldn't bring those arguments against his former client. But is that a disservice to Charlie? And is that a conflict that could not be waived? And it seemed that Charlie didn't waive. That might render Charlie a new trial if Rashbaum really did represent Donna at the beginning of all of this. And based on what the defense is bringing forward, it's going to be difficult to argue that he didn't. Rashbaum, you've got some explaining to do. This is going to be very interesting. I'm going to be keeping a close eye on this because I am very curious what's going to happen and if Charlie's going to be granted a new trial because of this. It goes on to say in September 2024, Charlie was subpoenaed as a witness for the state for Donna's trial. In September 24, Rashbaum withdrew, it says, and or was removed from Donna's case by the trial court on the eve of jury selection on the basis of Rashbaum's conflict with Charlie Adelson. Yeah, removed is the word you're looking for. He was like, please don't fire me, let me quit, but same. It goes on to say in October 2024, the trial court on its own motion removed the remaining defense counsel for Donna Adelson on the basis of Rashbaum's conflict of interest and the lack of a sufficient ethical wall. The ethical wall means that there wasn't information shared between the attorneys and you prevent one attorney's information or knowledge from tainting the other attorney. And that was not done here, or at least not done sufficiently for the trial court. The trial court was so frustrated when this all went down. He was like, how are we here? And that's when everything came out, that there was no waiver for Charlie after his trial that his mother be represented by Rashbaum. But it seems that there was no waiver for Charlie before that he be represented by the attorney that Donna wanted. And is Donna really the mastermind of all of this, wanting her attorney that has her interest in mind also representing her son? I can't imagine. But again, if all of this is not refuted sufficiently, this might be a new trial. So we will see what the response is to this. The response isn't going to be to the full motion. The response is going to be about whether this should go back to the trial court and have the trial court decide it. But again, the state's at a real disadvantage here because they don't know what was going on with Rashbaum and with the Adelsons. It's not any of their business. So the state, it'll be interesting to see if they say, no, there was something on the record. I imagine that the appellate counsel isn't going to misrepresent that fact. So we'll have to see. But when the state responds, I will keep you posted here on Quick Bits because this case is gotten a lot more interesting with the fact that Charlie might not have been advised or have waived the conflict of interest with his attorney for trial. And speaking of attorneys who want another trial, we got to talk a little bit about Tom Girardi. I know it's so many to pick from. We could be talking about Murdaugh. We could be talking about Girardi. Terrible lawyers for 200, Alec. Let's go to Girardi first. You might remember Tom Girardi, not just because his estranged spouse, Erica Girardi, is on the Real Housewives of Beverly Hills. But because I have been talking about this case since 2020, when the wheels came off of everything Tom Girardi, he was a very high profile and respected plaintiff's attorney in Los Angeles. He had relationships with just about everyone you can name, not just in Los Angeles local government, but in California government and politics. It's wild. But he recently went to federal trial and was convicted of essentially stealing from his clients. We have seen this over and over in the bankruptcy proceeding that I was covering. We haven't wrapped up the bankruptcy. It's still ongoing, but a lot of those clients are not going to be fully made whole, which is incredibly frustrating. At the end of the criminal trial, we always expect to see some appeals. We expect to see a motion for new trial. I did not expect to see a renewed motion for judgment of acquittal or judgment of acquittal notwithstanding a verdict, JNOV, but he's asking for a renewed judgment of acquittal. That's going to be denied. There is plenty of evidence and sufficient evidence here for a jury to find him guilty of what he is accused of. But the motion for new trial wasn't based on anything other than Tom Girardi's competency. So with this motion for new trial, Tom Girardi is asking the court to grant him a new trial based on his competency. His attorneys say, quote, "The court should grant Mr. Thomas Girardi a new trial under Federal Rule of Criminal Procedure 33 because Girardi was and is not competent to stand trial, and the information brought to the court's attention during trial triggered its obligation to further inquire into competency. The court should therefore vacate the verdict and, if Girardi can regain competency, order a new trial." Remember, Tom Girardi had a very thorough competency hearing, and at the end of that, the court determined that Girardi was malingering or faking and talked at length about that. He was evaluated by experts for his defense team. He was evaluated by experts for the government. And at the end of that proceeding, the court found he was competent to stand trial. Trial competency is a fairly low bar, but the defense is saying that during trial, they brought something to the court's attention that should have triggered a new competency evaluation or inquiry by the court to determine ongoing competency. And it can happen that someone is competent to stand trial and then not, and then is, and then not. So competency is something that can change during states of the proceeding. Just because someone is found competent doesn't mean it always stays that way. And if someone is found not competent, it doesn't mean that always stays that way. So it really can ebb and flow in a case. And the defense is saying he should get a new trial because during this past trial where he was convicted, he was not competent during that trial. They brought two exhibits to this motion. Exhibit A is entirely filed under seal. We're going to take a look together at Exhibit B, which is an affidavit filed by the individual that was driving Girardi back and forth to court every day. And it's relating to the conversations that were had and how Girardi was acting while he was being transported back and forth to court. So looking at the affidavit of Tanya McAlpin, who said that she was hired by Girardi's family to transport him from his assisted living facility in Seal Beach up to federal court in Los Angeles, which is not close or easy with traffic in LA, every single day of trial. She said that when she would speak to him about what he had done the previous day, he would tell me, quote, that he had done things like gone golfing, had dinner, and met with clients. I knew his answers were incorrect because he had been in trial the previous day and is no longer an attorney. It goes on to say when trial ended for the day, Girardi would usually ask me to drive him to the Jonathan Club or his old home in Pasadena. The fact that Girardi had a standing table at the Jonathan Club, we saw in the bankruptcy how much money was being spent on his tuition. No, that's not the right word. What are your fees for a club like that? I don't know. Whatever the bougie fees are for the Jonathan Club, those fees were substantially expensive and were part of the bankruptcy proceeding, or would ask to be driven to his old home in Pasadena. It goes on to say, because I had to drive him to his assisted living facility in Seal Beach, which is about an hour's drive south of the federal courthouse in Los Angeles, he would realize that we were not going to the Jonathan Club, which is in downtown LA, or his old home in Pasadena, which is the opposite direction from LA as Seal Beach, which means he perceived or at least ascertained where they were going, what direction they were going, and his surroundings. It said that he would become angry. On at least 4 occasions, he attempted to open the car door and leave while we were stopped at traffic lights or stop signs. For this reason, I usually locked the child lock to prevent him from opening the car door while I was driving. It said Girardi would also raise his voice to insist on going to the Jonathan Club or his old home and would tell me that I was, quote unquote, fired. When he was in a better mood, Mr. Girardi would sometimes say that he would give me a $20 raise, even though he does not pay me. On several occasions, I had to call Girardi's brother and guardian, Robert Girardi, so he could calm Mr. Girardi. Remember, Tom Girardi is in a conservatorship that happened right as the bankruptcy proceedings got started. This was a forced bankruptcy, not chosen. It was the creditors that forced Girardi into bankruptcy, and his brother put him in a guardianship. The guardianship does not itself impact the court's determination of competency to stand trial. They are different standards in 2 very different court systems. It goes on to say, on other occasions while I was driving Girardi from court after trial, he would comment that he needed to get home before his kids, who he said were in high school. Later, he would sometimes remember that he had not seen his children in years. By the time we would arrive at Mr. Girardi's assisted living facility, he would forget that he had spent the day at his own trial. It finishes saying, I have seen Mr. Girardi since he was found guilty. I usually see him about every other day. When I ask him how he is doing, he says he's been in court all day. He does not appear to have any memory of the jury's verdict or the trial at all. He has not mentioned either subject to me. He has not appeared upset, sad, or otherwise unusually bothered since his trial, as you might expect someone would be after being found guilty. So that is the somewhat redacted affidavit that we can see. We cannot see the other redacted exhibit, but the defense is asking the court to declare essentially that during trial, Tom Girardi was not competent and therefore he should be granted a new trial if he becomes competent again. All of this is going to be heard on December 6th in Los Angeles in federal court. And I'm thinking that I want to be in Los Angeles on December 6th in federal court because I'm very interested to see how these arguments go down. That was originally the day of his sentencing. So will these hearings be denied and he be sentenced? I don't know. But I'm kind of tempted to see. And let me know if you'd like my take on what goes down in federal court on this case for the hearing on these motions. And as we talk about terrible lawyers and disgraced lawyers and disbarred lawyers, we have a little more Murdaugh to talk about. You might have seen headlines that Alex Murdaugh settled his case with Mallory Beach's family. And while the case is settled, Murdaugh didn't really do anything. This is not like all of a sudden Murdaugh saying, oh, I feel like I am ready to make amends. No, that's not what happened. And the consent order ending the case that was filed in South Carolina on October 14th makes clear that this was between the family of Mallory Beach and her estate and their attorney, Mark Tinsley, and the insurance company that held the policy on Alex Murdaugh's boat. If you are not familiar with what happened in the Mallory Beach case, Mallory Beach was a teenager that was on Alex Murdaugh's boat with Alex's son, Paul Murdaugh, one of the victims in the murder case. Paul was driving the boat seemingly under the influence when it crashed into a pylon at night. Mallory Beach was ejected from the boat and died subsequent to that. This litigation has been ongoing regarding not just the places that served liquor to Paul Murdaugh, who was underage, but also to Alex Murdaugh's brother, Alex Murdaugh himself, and others. So everyone in this case has settled except for Alex Murdaugh. And now we know a little bit more about why and how this settlement came to be, because we've got the court filings, because instead of headlines, we go to filings. You know, it's that whole facts, not fuckery situation. The settlement says this matter came before the court on July 27th to approve the settlement of the remaining claims in this matter. At the time of the approval, Progressive Insurance, who was the liability carrier for the boat, would not tender its coverage without receiving a full release for Alex Murdaugh. That simply means that the estate of Mallory Beach and their attorney, Tinsley, had to release Murdaugh from all claims related to the boat collision and the insurance carrier was not going to release funds or pay out policy limits until there was a full liability release. That is not uncommon in settlements. In fact, I don't know if I've ever seen a settlement personally where there hasn't been a full release. The purpose of settling is it settles all claims regarding to a cause of action. So that's not unusual. It goes on to say, as a result, the Beach family attorneys agreed to defer receiving $500 of their approved fees so that other settlements could be achieved at the time. So they said, yes, we'll wait, let's settle all the rest of the claims and we'll deal with Murdaugh later. It says, as a result, the action against Murdaugh was not dismissed at a time. Since that time, the receivership was liquidated. When everything went down, like all the way down, the assets Murdaugh had or could be grabbed went into a receivership to try to deal with all of the multitude of civil litigation. And while the criminal litigation was ongoing, the receivership has been liquidated. It's done. There's nothing left in the receivership. So there's nothing more to get from Alex Murdaugh. So I understand why now is a different position. Post-conviction on the murder case, post him being in custody, post being sentenced to 40 years on the federal case and the rest of it, and the receivership being liquidated, there's nothing else to get from Murdaugh. So even if they didn't release claims, the policy limits on the boat policy is $500,000. There's nothing more to get, and there's nothing to get from Murdaugh personally, because as much as anyone can find it, it's gone. So I'm not surprised that now we get to the point where the Beach family, through their attorney, are willing to release Murdaugh from all claims with regard to this, because there isn't anything else that can happen. There's nothing else to track down, and there's no more that is going to come from Alex Murdaugh, at least financially, and that's the way that civil settlements are reached, is financially. It goes on to say, recently plaintiff's counsel received the policy limits check of $500,000. Therefore, counsel for plaintiff and Mr. Murdaugh have submitted this supplemental consent order that merely outlines the receipt of the payment and asked the court to end the case. Since there are no additional funds to be paid, and the Beach family was and is aware of what was done and have consented to this procedure, I find this supplemental consent order, which outlines what was done and clears up the record, is sufficient to resolve the case. So at the end of it, it says, it is so ordered, with an exclamation point, which I appreciate. We love the punctuation. And that is the end of the Mallory Beach civil cases, because everyone has now settled those cases and paid on those cases. That doesn't end the inquiry for Alex Murdaugh, because he still has that pending appeal with regard to the ruling on his motion for new trial in courthouse Becky. But we will peek back in on that in a little bit, because like appeals often do, it is moving right along slowly. And speaking of appeals, we are going to be touching in on what's going on with Sean Combs's appeal, and his attorneys are asking for, well, a few things. Karen Reed's case is also pending appeal. We're going to talk about that on Wednesday. And the Menendez brothers seem to have a wave of support behind their habeas motion and renewed vigor, even though their appellate options ran out in like 2015, but we might see them being resentenced before the end of the year. And we're going to talk about all of that on the Emily Show this week on Wednesday. It will drop early on Wednesday because we're in trial, law nerds. So I will see you in the chat because we are in court. And if you don't want to miss a moment, you know where to go, lawnerdapp.com. I don't need to tell you. So thank you for being here. Thank you for being a law nerd. Thank you for hanging with me with the quick bits, even when they're not the quickest of the quick bits. And I love our Monday episodes. Let me know if you love the Monday drops too, because I'm real excited to see where these go in the year to come. So with all of that, thanks for being here. I'll see you in the next one. Bye. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.